Hello and welcome back to our third segment on the Property Practitioners Act.
We've seen some interesting changes in relation to what the Estate Agency Affairs Act says, and as I'm sure everybody will know, every estate agent at the moment has to have a Fidelity Fund certificate for every financial year. It's valid from the 1st of January until the 31st of December. What this Act now tells us, however, is that property practitioners will only have to have their Fidelity Fund certificates renewed every 3 years, which is quite a nice thing to know, that it's only every 3 years that you have to go through this effort to try and get your Fidelity Fund certificate. And I'm quite sure what this also means to those that are rejoicing at hearing that it's only every 3 years is, of course, that your fees are obviously going to be 3 times higher as well. So I don't think people must get too excited that it's only every 3 years. I'm sure the fees are going to be adjusted accordingly. I'm also quite sure that the reason why they're making it every 3 years is possibly because the legislator now knows that the workload of the fund is going to be so much higher, and maybe that's why they only wanted to apply every 3 years. It just buys them a lot more time to get through all this admin. Let's talk about one of the consequences of not having a Fidelity Fund certificate. And there we've seen a major change. Now, the common law at the moment is the following. The Code of Conduct and the Estate Agency Affairs Act, they tell us that if you are not in possession of a valid FFC, a valid Fidelity Fund certificate, you as an estate agent are not entitled to charge commission. What the law also says, however, is that assuming that a seller finds out after transfer of a property, for example, or once a lease agreement has come to an end, that his or her agent did not have a Fidelity Fund certificate, what then? Can the seller or the landlord now claim back commission? And what the appeal court has ruled some years ago is that in terms of how they interpret the current legislation, once you've paid commission, even though the seller was actually not obliged to pay you commission, the seller cannot claim it back. In other words, it's water under the bridge. So the way that the appeal court has interpreted the current legislation is it's more of a disciplinary offence to levy commission when you're not actually entitled to it, and that the consequences are more disciplinary than anything else. Now we look at this Act and it has changed it completely. What the Act now tells us is if a seller or a landlord should find out that you did not have a valid Fidelity Fund certificate at the appropriate time, that the seller can literally come and knock on your door and say to you, I want my money back. It can demand the money or the commission to be repaid, and the Act says that the funds have to then, or the commission has to then be repaid immediately. There's no timeline, you have to pay it back forthwith. And what the Act also says is if you don't pay it back forthwith, you're then guilty of a criminal offence. So they've elevated this whole thing from a disciplinary situation to a criminal one. So it's going to be far more incumbent on property practitioners to make sure that they have Fidelity Fund certificates in their possession. Otherwise, a seller can come and knock on the door at any time within 3 years. The Act also says that you have 3 years to claim your commission back, which means that any property practitioner that has done a deal without a Fidelity Fund certificate is going to have to worry about whether the seller or the landlord is going to come and knock on their door and say, right, I'd like my commission back, please. One concern that I picked up with the Fidelity Fund certificates is the question of when exactly you're supposed to be in possession of one. If one looks at the Act, at one point they talk about at the point of the transaction basically is when you need your Fidelity Fund certificate. At another part of the Act they talk about that you have to be in possession of a Fidelity Fund certificate up until date of payment. Now, many agents come and go. Property practitioners are going to come into the industry, they're going to go out of the industry. Sometimes your transfers or your rentals, they can take a few months, they can take a few years, depending on the situation. And as I understand the legislation as it reads now, basically it means that you're going to have to be in possession of a Fidelity Fund certificate from the day that the sale agreement or lease agreement is signed, right up until actual registration of transfer or until the lease actually comes to an end. If a property practitioner does a sale today and the transfer is now scheduled to only take place middle of next year, for example, in the meantime, this property practitioner decides, you know what, I don't want to be one anymore, I'm not going to bother renewing my Fidelity Fund certificate at the end of the year. So the transfer only goes through middle of next year. This estate agent was still the effective cause, is still technically supposed to be paid for the work that he or she did. But because of the way that the Act reads, it sounds as if this property practitioner does not have a Fidelity Fund certificate in his or her possession on date of transfer, when the money is due, now he or she is not entitled to payment. Now that's going to obviously cause chaos as well, because us as attorneys, we as conveyancers, we're the guardians of these funds. We need to ensure that we are carrying out what this Act says. Otherwise we could be held liable again vis-a-vis or towards the sellers or the landlords if we should be somehow involved in the holding or collecting of this the rental money. It's this type of poor drafting that is now going to create havoc when it comes to disputes. If sellers start disputing this, when sellers or your consumer becomes more and more aware of what this Act says, they're going to cotton on, and the next thing we know, we're going to see an increase in disputes about whether agents or property practitioners should be entitled to commission because of the existence or not of a Fidelity Fund certificate.
Estate agents will only have to apply for Fidelity Fund certificates every 3 years. But later on in that very same section, the Act says that a Fidelity Fund certificate will be issued and it will be valid until the 31st of December of the year to which such application relates. And that just doesn't gel with the fact that the Fidelity Fund certificate will be valid for a period of 3 years. It should be from the 1st of July of 2019 until the 30th of June 2022. It shouldn't expire at the end of the year. It's going to create a huge administrative burden on the Property Practitioners Regulatory Authority to issue them all at the end of the year. These words have just been cut and pasted from the previous Act, so no one's given any thought to this section. They've just cut and pasted words from the previous Act into the new Act, and it just makes no sense. Finally, on the issue of the Fidelity Fund certificates, there is a provision in the Act which prevents a conveyancer from paying commission to an estate agent unless they are in possession of a certified copy of that estate agent's Fidelity Fund certificate. One of the repercussions of this section will be that agents will be holding the purchaser's deposits, and these deposits will not be paid to the conveyancers, because then the agent will not have to rely on the conveyancer to pay them their commission. They'll be able to deduct their commission from the deposit and pay over only any balance that's due to the seller on transfer. And I don't know what that effect is going to be in the industry, but I think that's what is going to happen. And by so doing, the agents will then no longer have to rely on the conveyancers to pay the commissions.